Good morning, ladies and gentlemen. It's our pleasure to welcome you to the fourth of 5 days of our special symposium in the 35th year titled Hot Talk, Passionate Debate for a New Age. Today's topic is, as the others have been, is extremely significant and is certainly prominent in the news at this time. Recently, Choice Point from Atlanta, Georgia, unbeknownst to them, sold private data to a group that turned out to be criminals. And they had to testify this last week before the U.S. Senate Banking Committee in relation to revealing private information to illegal sources. And so I think our topic today is most appropriate based on that and other developments. And the topic is, of course, the right to privacy versus the public's right to know. And this is like other issues, it's complicated, and there are certainly legitimate issues on both sides. We are very, very fortunate to have two very distinguished speakers today who are qualified to address this issue. There are areas in which they agree, and of course there are areas in which they disagree. I will introduce both speakers and in the order that they will appear. First of all is Mr. Jack Van Valkenburg. He is from Boise, Idaho, and he is the American Civil Liberties Union's executive director in the state of Idaho, and has held that position since 1990. From 1988 to 1990, Mr. Van Valkenburg was the assistant city attorney or the prosecutor for the city of Boise. He has served on the executive committee of the Ada County Human Rights Task Force for a number of years and is interested in both human rights and civil liberties. Our guest earned a bachelor's degree from the Evergreen State College in Olympia, Washington, and he holds a doctorate of jurisprudence from Northeastern University School of Law in Boston. Our second speaker, also equally distinguished, is Jeff Jacoby. Mr. Jacoby has been an op-ed columnist for the Boston Globe since February 1994, seeking a conservative voice to balance what is often thought of as the famously liberal roster of commentators and writers at the Globe. The Boston Phoenix has described Mr. Jacoby as the region's preeminent spokesman for a conservative nation. Our guest graduated from George Washington University in 1979, where he was elected to Phi Beta Kappa. He earned a doctorate of jurisprudence degree from Boston University Law School in 1983. And among his other accomplishments, from 1985 to 1987, he was an assistant to John Silber, the then president of Boston University, a president that received lots of national attention. Would you join me in welcoming our two guests? We've asked each speaker to speak for approximately 20 minutes, and then, of course, there'll be time for questions from you. And you've been wonderful this week in asking very, very good questions with great respect. With that, Mr. Jack Van Valkenburg.
Thank you, Tony, and thanks, everybody, for showing up. Find where I put this. I really want to thank everybody who worked as well so hard to design such a fabulous week of activities. If the program, if the printed program reflects what a good time you're having, I think you're having a fabulous time. I wish I could have been here all week. And I do have to tell you that I love any excuse to get to northern Idaho. I don't get here enough. I just love the trees. Boise is a wonderful town, but it's a treat to be up here. And it's a treat to have this debate, because I love good debates. But, you know, when Tony asked me to be part of this program, I thought, privacy versus the right to know. Gee, I could probably be on either side of this debate. After all, the ACLU in Idaho is in court fighting for the right to know about public records, about our government. We are representing the Idaho Conservation League because they were denied access to public records. about how cattle operators handle all the poop that is created by their cows. We all thought it was a pretty shitty deal. So they asked us to represent them. We took the case because we think the right to know is a necessary corollary to the right to speak. You can't speak intelligently about government unless you know what the government is doing. So what I'm saying is, on the one hand, the ACLU is all for the right to know. In fact, I would argue that you can only protect your right to privacy, you only have privacy if you do have the right to know what the government is doing. It's the only way to make the government accountable is to know what the hell it's doing. However, on the other hand, the ACLU opposes the increasing non-consensual gathering of your financial data, your medical and other personal information. But then it is in this respect that the title of the program, The Right to Privacy versus the Public Right to Know, is followed by this troubling statement. Jack Van Valkenburg will support the position that the U.S. government guarantees Americans extensive privacy protections against both government and private organizations' intrusion into their lives. Well, Jeff, I concede defeat. Because all of you can now go home. Because I admit that the Constitution, as interpreted by the courts, offers little protection against intrusion by private actors. And in recent years, with the recent wars on drugs and on terrorism, courts are less apt to strictly enforce the Fourth Amendment's bar on unreasonable searches and seizures, i.e., the courts have been all too willing to allow intrusion, even when by government actors. So maybe I should just sit down. But then I think, how often do I have a captive audience like this? So I'll tell you some of what I think about the issue, even if the courts don't recognize strong constitutional protections against a lot of the intrusions that are occurring. As I said, the ACLU is certainly opposed to the increasing non-consensual gathering of your financial and medical and other personal information. Bigger monster, weaker chains describes the situation today in America. Do you know what I mean? The monster is the exploding surveillance industrial complex and the increasing power of the federal government provided by such Bush administration-inspired measures as the USA Patriot Act. The weaker chains are the pitiful efforts of our government, both our courts and our Congress, to control the monster or to even make it accountable. What am I talking about? Well, as Tony mentioned, what about what's just happened in the past month or so? First, ChoicePoint, then Bank of America, and 2 weeks ago, LexisNexis revealed the loss or the theft of millions of bits of sensitive consumer data. Every American can now contemplate the vulnerability of your personal data. Intruders sneaked into the databases of ChoicePoint and LexisNexis and gained access to dossiers on more than 170,000 Americans. At least 750 of them had their identities stolen. Yesterday's Wall Street Journal, as I was flying up, noted that ChoicePoint sold private data on 145,000 people to criminals posing as legitimate small business customers, a breach that people might never have known about but for a California consumer protection law. Bank of America lost consumer tapes that contained data on 1.2 million federal employees. What can you do to protect your privacy? Not much. The U.S.-based data brokering companies are huge. Axiom Corporation had $1 billion in sales in 2004's fiscal year. ChoicePoint had $795.7 million in sales. ChoicePoint says it has access to more than 19 billion public records, including motor vehicle reports, police reports, license and deed transfers, and military records. ChoicePoint has bought companies with databases of bankruptcies, civil judgments, and federal and state tax liens. ChoicePoint has more than 50,000 customers. The problem is mostly in America. Other countries have data privacy laws. In fact, every industrialized country except the United States has legal protections for data privacy. Why? Why in the United States don't we? Well, businesses have more political power in the United States. In Europe and Canada, they tend to regulate business. In the United States, we want to regulate the government. We don't much worry about business. In Europe and Canada, there are simple, clean privacy laws, and even a privacy commissioner that may sometimes halt a program. Europe and Canada have data privacy protections relating to permission. Do you consent to the release of your information? To notification, once the data gets collected? To access to the information? To the right to correct the information? Limitations on the purpose, specificity, and use of the information? And they have security protections. But in the United States, businesses jump into the legislative process, turning any bill for a simple privacy law into a hodgepodge, complicated mess that treats different kinds of records differently. What's even worse is that the ACLU has had to fight like dogs to keep the Bush administration from promoting and exploiting more data accumulation. The Privacy Act of 1974 banned the government from maintaining information on citizens who are not the targets of investigations. But law enforcement agencies are increasingly circumventing that requirement by simply purchasing or otherwise acquiring information that has been collected by private data aggregators. You know, there was TIPS, the Terrorism Information Prevention Program that Bush called for, President Bush, George W., in his 2002 State of the Union address. Utility and cable company employees were to report on you. You probably remember this. Thank goodness public pressure killed that. Then there was even worse, the Total Information Awareness Program. John Poindexter of the Contra-Iran scandal fame, that's a data mining program. The idea was to tap into the ever-growing number of databases containing details on individuals' behavior, aggregate that data to form rich pictures of individuals' activities, and then use computer models to scrutinize them en masse for suspicious behavior. Data was to include financial, medical, travel, place entry, event, transportation, housing, and communications information. Virtually anything you did was going to be added to Poindexter's TIA program so that they could sift through this haystack of information looking for the needle. Public pressure killed the program, but not the concept. A big problem is how the administration has reacted to 9/11, further promoting data collection, but also expanding governmental power to search the innocent, your records, your computer, even your home. They have cast a net of suspicion as wide as they possibly can. For instance, the Total Information Awareness Program. The fact is, terrorists are rare. They are like a needle in the haystack. The government could focus on being smart, listening to reports of terrorist activity and investigating them with the proper procedural safeguards. That way they could hope to find the needle, the terrorist, in the haystack. But the government would rather look for the needle, i.e. the terrorists, by adding more hay to the stack. This approach doesn't work. For example, the hundreds of immigrants who were rounded up and detained after 9/11, many for months, none were found to have a connection to 9/11. But I note the Justice Department still boasts that, quote, hundreds of immigrants linked to the 9/11 investigation were deported. They were targeted simply because they were immigrants. And while the government thinks all of us could be terrorists, they really suspect immigrants. Then, in Idaho, an example is the prosecution of Sami Omar al-Hussein. What if you're an immigrant from an Arab country who is studying computers? A shiny needle in the haystack. That's what, with hardly more evidence than that, 2 years ago, the Justice Department arrested and prosecuted University of Idaho graduate student Sami al-Hussein. He spent 1.5 years in jail before he was acquitted. He had a wife and 3 kids in Moscow while he was in a jail cell in solitary confinement for all that time in southern Idaho. All it took was a Foreign Intelligence Surveillance Act warrant, a FISA warrant, made easier to obtain thanks to the USA Patriot Act, and the government intercepted 9,000 phone calls and 20,000 emails of Sami's, none of which his attorneys or he could ever access. But did they produce a guilty man? No. They just produced Arab and Muslim alienation from our government, just as they did by rounding up all those immigrants. And how can we find Islamic terrorists in the United States if we keep alienating the innocent? Bottom line, this approach of piling on the haystack of data and people to be suspicious about is often counterproductive to protecting security and defending freedom. It both, one, undermines security by ignoring the effectiveness of community policing. You know what community policing is. It's when, because we care about each other, we care about our public safety, when we see something suspicious, not a government-inspired program like TIPS, but in your normal course of living, you learn something. If you're an immigrant or not an immigrant, you report it to law enforcement. That is the way we can combat terrorism in the United States. The immigrant community could help us. Instead, we alienate them. The other thing it does, besides undermine security, is this idea of piling on the haystack undermines freedom. We are spied upon without probable cause. We have a choice about our democracy. We can either follow our fears or we can be led by our values. Terrorist attacks are designed to frighten us even more than to kill us. So let's refuse to magnify the damage they do. We can show that we are free and brave people by controlling our fears and respecting our freedoms. That is, if we don't waste any more time on make-believe, seemingly impressive security measures that compromise our freedoms but do not make us safer. Thanks again for inviting me to speak.
And now, ladies and gentlemen, Jeff Jacoby.
Tony, thanks so much for that great introduction. And Jack, thank you for preceding me with provocative comments, an awful lot of which I share. Now, how am I going to fit the water in here when you have to tilt the bottle to get it in? All right. What we should have brought were cups. Ladies and gentlemen, it's a great pleasure to be here. This is my first visit to Idaho, and I'm only sorry that I won't be able to be here even longer before going back to Boston. As many of you, I'm sure, know, Boston and Massachusetts are great hotbeds of opposition to the Bush administration, real strongholds of liberalism. And just before I came out here, I was hearing a story about John Ashcroft, the former Attorney General, who apparently had been visiting a public school in Boston shortly before stepping down as Attorney General. And I guess he got up before a class of grade school students and made a few comments, talked to them about whatever issue we had come to discuss, and then opened the floor for questions. One little boy, Johnny, raised his hand and said, Mr. Attorney General, there are three things that I'd like to ask you about. First of all, why did you cover up that naked statue in the Justice Department? And number two, is it true that we're torturing detainees down in Guantanamo? And number three, isn't it true that the Patriot Act intrudes on our civil liberties? And before he had a chance to answer, the recess bell rang, and all the kids leaped up and ran out to recess. Well, they came back when recess was over, 20 minutes later, and once again gathered, and again the floor was open to questions, and this time Sally raised her hand, and she said, Mr. Attorney General, I've got 5 questions to ask you. Number one, is it true that you covered up a naked statue down in the Justice Department? Number two, why are we torturing detainees in Guantanamo? Number three, isn't it the case that the Patriot Act infringes on our civil liberties? Number four, why was recess 15 minutes early today? And number 5, what happened to Johnny? The point, of course, is that it's very easy, if you want, to be able to find all kinds of things to worry yourself about, to be suspicious about, to assume the worst motives on the other side about, and to make yourself even more fearful of the government than citizens reasonably ought to be. Sorry to keep bopping up and down, but I've figured out the solution here. We poured the water, the cup fits, see? That's why I went to law school. I have to say, I agree with a great deal of what Jack Van Valkenburg says. I, too, am concerned about the fact that vast amounts of our private information are available to people who are willing to pay for it almost anywhere. I'm not sure that lawsuits or that statutes passed by the federal government are going to prove to be the most effective way of controlling the use of that information. I think that with data brokering, as with so many other areas in the private sector, it will be public pressure that will bring about the most effective kind of changes in the way those materials are used. But what I want to focus on, at least in the few minutes that I have here to begin with, before we go to your questions and comments, is the relationship between individuals in this country and the government, especially since 9/11. On September 11, on the day of the attacks themselves, a guy at Harvard Law School named John Perry Barlow, who is the founder of something called the Electronic Frontier Foundation, a great supporter of privacy in the electronic realm, the computer realm, sent an email out to his huge mailing list in which he said, "Control freaks will dine on this day for the rest of our lives. Within a few hours, we will see beginning the most vigorous efforts to end what remains of freedom in America." On 9/11 itself, there was somebody concerned about civil liberties saying, "That's it. Freedom is over in America, and just you watch what the control freaks are about to do now, using 9/11 as an excuse." Jack's organization, the ACLU, has said that the Patriot Act allows the FBI, in its words, to spy on a person because they don't like the book she reads, or because she wrote a letter to the editor that criticized government policy. Russell Feingold, U.S. Senator Feingold, gave some advice, which I guess means if you own stock in Amazon.com, you should sell it, because he said that ever since 9/11, because of what the government has been doing, intruding into our realm of privacy, Americans have become afraid to read books, terrified into silence because of administration counterterrorism efforts. So I guess I'd like to begin by asking all of you to do a gut check and ask yourselves if this really rings true. Is there anybody here who's really afraid to read books today? Is there anybody who thinks that you don't dare criticize the administration? We just came through a presidential campaign last year in which the most vehement and unrestrained criticisms and denunciations and damnations of the Bush administration could be heard from sea to shining sea. The debates among the Democratic candidates for president were no-holds-barred events in which there was no shortage of invective when it came to criticizing what the administration has done, even focusing on what it has done with regard to terrorism and 9/11. We had, it even went to the extent of videos that were produced and for a while posted on the website of the liberal organization MoveOn.org that explicitly compared George W. Bush to Adolf Hitler. Whether you think it's a fair comparison or an outrageous comparison, surely we can all agree that if people are being rounded up and sent to prison for criticizing the administration isn't doing a very good job of rounding them all up. Now, I make my living as a journalist. Every day of my, every working day, the First Amendment protects what I do to earn a living. I care very deeply about civil liberties. Although I'm described politically as a conservative, there's a strong libertarian streak in my approach to politics. I bristle at the idea of government intrusion where it doesn't belong. I don't like taking my shoes off when I have to go through the airport. It bugs me that the government's able to control even the way I dress or what I'm wearing at any given moment. And yet, I recognize that for all the irritations that we may sometimes feel, that by and large, civil liberties are alive and well in this country. And when you consider what the case would be in other countries, had there been an attack along the lines of 9/11, when you think about how ruthlessly civil liberties would have been cut down, it's really a great reflection on us and on our defense of freedom in America that we remain as free, both in our private lives and in what we're able to do and say publicly, as we are to this day. None of which changes the fact the fundamental fact that we are at war. We are meeting now in wartime. It may not feel like war as you walk through the streets of Coeur d'Alene, but this country is at war. 9/11 was an act of war by foreign enemies who had hidden within our borders. Not just enemies abroad, but enemies from abroad who were here. They murdered 3,000 of us. It was the greatest loss of life in America since the Battle of Antietam in the Civil War. And unless they're prevented, they're going to do it again. Those are the stakes. Everything that we're talking about is in that context. This is a real war. Unlike the war on poverty that Jack mentioned, this isn't a metaphor. It's not a metaphorical war. This is a genuine war. And one of the fundamental differences between life post 9/11 and life pre 9/11 is the way in which the government looks at terrorism. Pre 9/11, terrorism was a crime that would be dealt with through prosecution. Whenever there was a terror attack, the president or the attorney general would get up before the microphones and say, "We will not rest until we have found the perpetrators and brought them to justice." How many times did we hear them say that? Post 9/11, the paradigm is very different. Today, the paradigm is we prevent the act before it takes place. We get the information, we find out what's going to happen, and we stop it before 3,000 people get killed. There's so many different aspects of this that we can talk about. Clearly, the one that has gathered the most attention, and perhaps it will have time to go into even more detail when you guys begin participating, is the Patriot Act. Jack mentioned it a little bit. Let me just say a couple of thoughts about it. First of all, that law was passed with overwhelming majorities in both houses of Congress, Republican majorities as well as Democratic majorities. It extends, for the most part, powers that already existed, powers that were already being used by police and prosecutors going after drug dealers, for example, or child pornographers, or organized crime figures. It extends those powers to the terrorism, counterterrorism arena. So, for example, it gave, the biggest change that the law brought about was to tear down the wall that separated the intelligence wing of law enforcement from the criminal investigation wing, so that those agents in the FBI who dealt with counterterrorism are now able to talk to people in the FBI who deal with law enforcement. Before 9/11, there was an artificial wall that was put between those two. Understandably, when you think about the kinds of things that we worried about before 9/11, there was a great fear that there would be domestic spying. And we didn't want the government to be engaged in that, and so we put up this great wall. Spies couldn't do any of their work domestically. Intelligence people wouldn't talk to law enforcement people. Here's what that led to. There was an FBI agent on the West Coast who was looking for a couple of people, one named Khalid al-Midhar and one named Nawaf al-Hazam. He wanted to talk to the intelligence side, the counterterrorism side of the FBI, but because of that wall of separation, he wasn't permitted to. So he had to drop that investigation and was never able to track those two people down. They turned up. They turned up on 9/11. They were at the controls of the plane that flew into the Pentagon. The Patriot Act makes it possible for information that's being gathered on terrorist attempts to harm Americans and to make that available to those who are trying to prevent those kind of crimes from taking place domestically. One other thought. I know that we're, how are we doing here on time? We have a little bit more. You walk into some of the public libraries in Massachusetts. I don't know if that's the case in Idaho as well, and you can see signs now at the front desk warning you that any transaction that you undertake in the library may be reported to the FBI without your knowledge. This is a reference to Section 215 of the Patriot Act, which has gotten a great deal of attention, in part thanks to the ACLU, in part thanks to the American Library Association, which has whipped up this great fear, this great concern that Americans' library records are now going to be snooped at and pored over by federal agents. Interestingly, Section 215 doesn't mention the word library. It doesn't say anything about borrowing records at public libraries. What it talks is about the right of investigators with the court order. They have to first get a court order. When they are involved in counterterrorism cases, when they're involved in intelligence, to be able to get tangible things, business records, credit card receipts, telephone records, library records, if there's a use for them, tangible things, in order to further their investigation. Once again, this is a power that has existed for years. It just never existed before for counterterrorism work. It existed if you were an agent working to try to break a drug ring. It existed if you were going after child pornographers. It existed if you were trying to break a mafia hitman squad. For those areas, this power was available. It wasn't available for counterterrorism. I don't think there's anybody who would argue post 9/11 that if there are records out there that investigators are able to use to prevent an attack like that from taking place, that there ought to be some reasonable method with appropriate protections for civil liberties for them to get hold of those records. You can argue about whether the Patriot Act provides enough or not quite enough of those protections. But when it requires that agents have to first go to a court, get a court order, when it specifies in the law that it may not be used, Section 215 itself says that it may not be used to pursue people merely for activities that they are engaged in pursuant to the First Amendment of the Constitution. It says that right in the law. That seems to me to be a reasonable protection. Another section that's often spoken about is so-called sneak and peek power, Section 213 of the Patriot Act. It has, by the way, 157 sections. It's a very long bill, the vast majority of which, even according to the ACLU, isn't controversial at all. It's neutral when it comes to civil liberties. There are maybe 10 or 12 sections that have raised some controversy. And most, if not all of those 10 or 12 sections are scheduled to expire this fall. They will only remain in law if Congress affirmatively votes to extend them. That's part of the reason we have debates like this one, so that citizens can come together and discuss these matters, discuss these laws, and be able to convey to their lawmakers whether they want laws like this to continue in force or they want laws like this to be repealed. Section 213, sneak and peek, the term of art is really delayed notification. It allows, again, in appropriate cases, for investigators to be able to conduct a search but not notify the subject of that search until some time has elapsed. Once again, this is a power that's been available to investigators in other kinds of law enforcement investigations, such as, again, drugs or pornography. But it hasn't been available when it comes to those investigating terrorism. And if you think about it, it makes perfect sense that you wouldn't want to have to, once you get your search warrant, to go into the house and leave a note that says, "Dear Mr. Bin Laden, we were here this morning looking for such and such." You don't want to be tipping off the subject of your counterterrorism investigation that you're on to them if your whole goal is to prevent the attack from taking place. Remember, this is not going after somebody to prosecute them after an attack, in which case the full panoply of due process protections are absolutely appropriate. If you're caught after a terrorism attack takes place, if you're David Kaczynski, the Unabomber, and we track you down and we put you on trial for mailing bombs to university professors, you're entitled to every protection that the due process system guarantees you. Right to an attorney and to a jury trial and all the rest of it. But if the government is trying to prevent your attack from taking place in the first instance, then it doesn't make sense to say that you have to first be provided with every possible protection against the government before the government can do anything to stop you from killing. And by the way, the Unabomber was one case in which library records actually were relevant to tracking him down. You may remember that it was a tip from his brother that finally put the police onto the track of this killer. He had gotten the New York Times and the Washington Post to publish a huge manifesto in their newspaper, several pages long. This is about 9 or 10 years ago. And in the course of it, he mentioned a number of very abstruse books that are not well known at all. Library records turned up the fact that he had checked those books out. And it was that piece of corroboration that helped nail down the case against him. It's sometimes made to seem as though the Patriot Act and the kinds of concerns that we're talking about today are the sorts of things that Republicans don't care about and only Democrats do care about, or that Republicans are the ones who want to trample on civil liberties and Democrats are the ones who want to protect them. So it's interesting, it seems to me, to know that some of the strongest defenders of the Patriot Act and these post-9/11 expansion of powers that enable the government in appropriate cases to be able to intrude on individuals' civil liberties and privacy rights have been supported by some of the most prominent Democrats in the country. Janet Reno, who for 8 years was the Attorney General during the Clinton administration, said that everything done with the Patriot Act, everything done with the Patriot Act has been helpful to fighting terrorism. Joe Biden, the senator from Delaware, said that the tide of criticism against the law is both misinformed and overblown. I stand by my support of it. Dianne Feinstein, from that well-known right-wing state of California, at a hearing in Congress, said that she had received 21,434 complaints about the Patriot Act. 21,434 complaints about the Patriot Act. Most of them turned out to be unrelated civil liberties complaints or objections to laws that haven't even been passed. And she said, quote, "I have never had a single verified abuse of the Patriot Act reported to me. My staff emailed the ACLU and asked them for instances of actual abuses. They emailed back and said they had none." It's very easy to let ourselves get whipped up into a kind of frenzy of fear that our liberties are being taken away from us, that we have no more freedom, that we don't dare criticize the government, that our zone of privacy has been shredded. It isn't true. I'm glad that there are people who do get overly concerned about it. I think that helps keep us free. I'm glad that there's this tension between those on one side who say that we have nothing to worry about, those on the other side who say that we have everything to worry about. It makes those of us in the middle who can see merit on both sides a little bit more reassured that the proper balance is being struck. And in the end, balance is really what this is all about. There was a story that appeared in USA Today a couple of months ago. The headline says, "Poll, nearly half of Americans for limiting Muslim Americans' rights." The story begins, "Nearly half of all Americans believe the U.S. government should restrict the civil liberties of Muslim Americans, according to a nationwide poll. The survey showed that 27% of respondents supported requiring all Muslim Americans to register where they live with the federal government. 22% favor racial profiling to identify potential terrorist threats, and 29% think undercover agents should infiltrate Muslim civic and volunteer organizations to keep tabs on their activities and fundraising." Now that's after one 9/11. I ask you to just stop for a moment and think about what the reaction will be like across this country if, God forbid, another 9/11 happens. If there's another day in which thousands of Americans are killed by terrorists who weren't found and prevented in advance. Then there will be a cry for rolling back civil liberties from one end of the country to the other. Then there really will be a shredding of our privacy and a loss of our freedom. And it will come not because the government will go haywire, but because there will be a demand for it from the streets. 44% say Muslim Americans should have less rights than everybody else. If that's what they're saying, that was December 2004. If that's what they're saying 3 years after the first 9/11 attack, just think about how freedom is going to suffer if there's another one that takes place. And that's why I say, by way of concluding, that the greatest threat to freedom in America today, the greatest threat to our privacy, the greatest threat to the liberties that we take for granted as American citizens, is not any of the reasonable laws that have been passed since 9/11. It's not any of the activities that government agents are undertaking to try to prevent terror attacks before they happen. The greatest threat is the threat that there will be another terrorist attack. If that happens, then truly, Katie bar the door, because our civil liberties and our right to privacy and the freedoms that we take for granted as citizens of this country will truly be endangered. Thank you very much.
We thank both speakers very, very much, and it's very inspiring, and I'm sure it'll create a lot of questions, and John is raising the microphone here. If you'll please come to the microphone, you need to do two things, please. State your name and then ask your question. We want to get in as many questions as possible, so if you would refrain from a speech yourself and ask the question, it would be greatly appreciated. And we're taping this, so we want to get it on the microphone. So please feel free to come forward, and both speakers will address every question. The microphone is right here.
How you doing? Vic Larson, University of Idaho. I really have a question for Mr. Jacoby. Hope I'm pronouncing your name correctly. And really, it's not a rhetorical question about constitutional law or anything like that, but I'm curious. You seem to know a lot about 911, and it's central to your argument. I'm just wondering, do you know what happened to the wreckage of the 767 jumbo jet that allegedly flew into the Pentagon?
Do I know what happened to the wreckage of the plane?
Where is that wreckage?
I don't.
Where are the bodies? Where are the remains of the fuselage?
Sorry. Those
Thank
details I don't know. Baby Jack?
Next question.
I'm Kathy Matresi. My question for both gentlemen is, how do you then look at people who have been excluded from going to listen to President Bush discuss Social Security, such as in North Dakota, when people who were excluded seem to have the commonality of having written letters critical of the Bush administration in the newspaper, or having been members of the group MoveOn.org?
That's actually a question and a complaint that I agree with. I think that it's ridiculous that this administration imposes ideological litmus tests on who can attend rallies. On the other hand, I recognize that a political rally can be made an admission-only event if the people organizing it want to. Foolish as I think that is, and foolish as I think it is for them to be so concerned that there may be a heckler who will get a few seconds of exposure on the evening news, I don't regard that as an infringement on American civil liberties. I think it's simply a silly political decision. I didn't like it during the presidential campaign when the White House always made sure that only Republicans or only people who were registered as supporters of the Bush administration were able to come to their rallies. They've got the freedom to do it. It's not, as far as I can tell, a legal violation or a civil rights violation. I just think that politically it doesn't make much sense.
Well, I certainly agree with Jeff that that is a bad use of government power, and I think it reflects the Bush administration trying to, in effect, narrow the landscape of expression, particularly around any event that it is holding, so that only its message gets out. It relates to their, in recent months being exposed to have created, in effect, false news reports by paying conservative commentators, but not having the commentator mention that he's being paid by the Bush administration in order to promote a Republican conservative philosophy. I think it's sort of a cynical way that the people in power today are taking advantage of our ignorance, and they're taking advantage of the fact that we don't step up and say and call bullshit when things like that happen. And very rarely do you hear people crying bullshit when there are these Republican events that don't allow other people to attend. I think it's our responsibility to do that, and I hope that I hear more about it in the future.
My name is Sandra Boynton. I'm a new resident from Florida as of October. And the lady actually asked my question, but I'm very angry about what's going on about people being banned from Bush's speeches. But my question is to Mr. Van Valkenburg. I would like to know why the ACLU is not looking into this, because from my understanding, they're using my tax dollars to put these shows on, and I resent it. I agree that someone should not go into a meeting and yell or scream or be disrespectful to the president. But if you're there truly to listen and you're an American taxpayer, I have as much right to be there as a moderate Democrat as any Republican in this United States of America. And I'd like to know what you're doing about that.
All right.
Well, I think it's an excellent question, and I'm going to be talking to others in the ACLU about what are we doing? Are we doing anything? If we're not doing anything, why aren't we doing anything? I think it may come down to this mushy middle, so to speak, of what rights do public officials have, candidates or elected officials when they run for office, to control the parameters of the venue at which they speak. For instance, one could argue that no public money should go to support a public official's candidacy, and that sounds perfectly logical, and yet there are these opportunities that incumbents have to use the fact that they are theoretically just serving their interests of their people by traveling to their home state and where they spend a lot of their time and money campaigning. There's a line that needs to be drawn. I don't know where that line is. Maybe Jeff does, but I would think that that's something that we have looked at or are looking at, and I certainly think it's an important issue for us to address.
We've obviously come a long way from the days when there was no wrought iron fence, never mind Secret Service guards, surrounding the White House, and any citizen off the street could just walk in and go in and ask to see the president. You read the biographies of President Lincoln, for example, and they talk about how much of his time was taken up often simply with having to greet people who were coming in off the street in Washington, D.C. because they were in town and they wanted to speak to the president. As I said in answer to the first person who asked the question, I think it's politically foolish. I don't know that it's illegal, but I'd like to see it stopped. On the other hand, if what you're really concerned, and I see we're talking more about free speech issues and privacy, but if what you're really concerned about is freedom of expression, then a far greater and more insidious threat than simply President Bush's political organizers making sure that their rallies are packed with their own supporters, which frankly is something that politicians of every stripe try to one extent or another to do. A far greater concern to all of us ought to be the federal law, the McCain-Feingold law, that makes it illegal for interest groups to run advertisements within 30 days of an election that mention the name of a candidate that they're opposing. If you're really concerned about the loss of free speech in this country, the notion that there's a law that says that you cannot put an ad on TV that says vote against throttle bottom within 30 days of the election when throttle bottom is running, that's something that really truly ought to concern us. And I hope that challenges to McCain-Feingold, which is very badly misnamed campaign finance reform, is something that the ACLU will be just as engaged in as concerns about who's allowed to attend political rallies. Because frankly, the political rallies come and go. We've got them on both sides of the political aisle. When debates take place among the candidates, both campaigns bring people in, but this law remains on the books until it's repealed. That's something I think ought to concern all of us.
Can we get our next question, please? Who has the next question?
Hi, my name is Amy Mossberg, and I'm a student here at NIC as well as in the student government. And I probably speak for the majority of us that we all want freedom, privacy, and our safety. And you both bring up very legitimate points in both these areas. My question is something that Mr. Van Valkenburg brought up. I'm kind of confused about what businesses and private organizations having access to citizens' personal information has to do with the Patriot Act versus the government having that information. Thank you.
All right. Let me first, before I forget, though, respond to Jeff's comment about the campaign finance reform laws or the McCain-Feingold. We are, in fact, in court, and I've spoken to the attorney for the National ACLU working on that case. I agree with Jeff with respect to those restrictions on free speech, and I'm going to make a point and then answer the question, but back to the free speech point, I think it's another important point to consider is that while government, and I think Jeff admits that the government since 9/11 has been expanding powers to invade into our private lives. It's just that we disagree on the level at which that is appropriate, the degree to which that is appropriate. They, at the same time, the government is constricting the ability of us as people to understand what the government is doing. And that is a very dangerous situation when government has increasing power over all of us to invade our homes, our computers, our medical records and whatnot, and yet we have less and less power, as exampled by studies of the Freedom of Information Act and by analysis of all the government regulations and orders that have come down since 9/11. We have less and less power to understand what the government is doing. And as a libertarian, I hope that Jeff would oppose that trend. Now, in the answer to the question, what I took the question to be, and correct me if I'm wrong, is that what does the Patriot Act have to do with the increasing ability or tendency of private companies to accumulate data? Really, there's a lot about things that have happened since 9/11 that are thought to be Patriot Act, and the Patriot Act is responsible for only some of them. And I don't, on reflecting about it, believe that there is a connection. There might be in one of the provisions that I'm overlooking right now. But no, I think the Patriot Act expands the ability of certain portions of the Patriot Act. There's various things, and I would love to rebut Jeff's comments about it, and perhaps there'll be a question that allows me to do that. But with respect to the Foreign Intelligence Surveillance Act, for instance, the Patriot Act allows the government to have access to your personal property, your personal records, your computer, etc., with less than a probable cause showing. So that, traditional criminal law procedure is that the government does not get to invade on your space, on your life, without a showing that there's probable cause to believe that you are acting in a suspicious way or doing something that's criminal. Well, that's not the case with Foreign Intelligence Surveillance Act. They don't need to show probable cause. There's a different standard, which we can talk about if you care to. But the answer to the question is I don't see the relation. Maybe.
Why don't you go ahead and why don't you two do that?
Okay.
What you ordered, Jeff, you two dialogue.
Let me make 2 points. It's true that there is no specific connection between the Patriot Act and concerns about financial data and so forth that's out there publicly available. It came up, I think, in the course of Jack's original remarks because he was talking about a program that got shot down before it went into effect. It was called the Total Information Awareness Program. Admiral Poindexter was in the Pentagon, who was the guy who was overseeing it. I think that it was shot down for bad reasons. I don't think that it would have been the kind of 1984 scenario that an awful lot of critics worried about. Here's the point. All kinds of information about you, your name, your address, your date of birth, where you live, what you buy, your credit card records, your phone number, your phone records, so much of that stuff is already available on the market, out in the commercial sphere. It's available to Visa and MasterCard. It's available to Palmolive Gold, or who makes P&G? What does that stand for? Procter & Gamble. See, the P&G stuck. It's available to big corporations that are trying to refine their marketing techniques. It's available to advertising firms. What TIA, the Total Information Awareness Program, would have done is enable the government to engage in this kind of data mining itself, to do exactly what Jack said it was interested in doing. His metaphor was exactly the right one, looking for a needle in a haystack, trying to find one Mohammed Atta or 19 terrorists out of 280 million people in the United States is an enormous, enormous endeavor. But if using commercially available data, this would not have involved going and digging out information about you that nobody previously knew. If making use of data about you that's already available in the market could have revealed patterns of behavior, of phone calling, of purchasing activity that might have given reason to suspect that right over there, or over there, or over there, there might be a needle located, might have saved an awful lot of lives, and I'm not sure that it would have been something of great concern. The other thought that occurs to me, we spent so much time today talking about privacy. Where privacy is mentioned, not by that word, but most specifically in the Constitution, is in the Fourth Amendment. The Fourth Amendment is the one that protects citizens against unreasonable search and seizure by the government. And the key, it seems to me, is the word unreasonable. If there is, in the words of the Bill of Rights, such a thing as unreasonable search and seizure, that means that there's also reasonable search and seizure. And the job of lawmakers and the job of judges is to decide where that balance should be struck at any given moment. And the balance will be different depending on what the challenges are that are confronting us. And I think it should reassure all of us. I would say it, and Jack will agree, and I think everybody here knows it instinctively. Any one of these things that gets challenged in court that ends up getting struck down, and on appeal that striking down of a law is upheld, will end up being struck down. The government, the Bush administration, the Justice Department is not going to insist on carrying out section so-and-so if the Supreme Court says that section so-and-so is unconstitutional. We really do live in a nation of laws, not of men, to use Madison's phrase. And when our legal system, culminating in a constitutional ruling by the Supreme Court, says that such and such a practice or so-and-so a technique that the government had been engaging in may not be engaged in, it stops being engaged in. And that is should be a great reassurance to all of us after more than 200 years of constitutional law to know that our respect for law and our elected officials' respect for the legal system is so strong that when they are ordered not to do it by a court that has no army of its own, that can't send out a militia to enforce it, it complies. That should give all of us reassurance.
What we're going to ask, Jack wants to make another comment in another area, and then we'll let Jeff respond to that, because I know you want to do that. So.
Great. Well, I was just taking some notes on Jeff's comments, and I'm glad to have a chance, because otherwise it's unfair to go first. No, it's all right. They aren't much. It's just that Jeff, like other commentators regarding the Patriot Act, has said some things that I can't let slide. One would be, so he's absolutely right. Section 215 of the Patriot Act does not mention libraries. What's the point? Why do we hear that? It mentions business records. Nobody denies that library records, that business records include library records. And the fact is that librarians do have reason for concern. Librarians are educated people. They're not idiots. They had reason for concern, and they, in some communities, and I think Moscow is one, Coeur d'Alene may not be, but should be. Sandpoint has a resolution that directs their libraries to post those signs that say, beware. What you read or check out, the records of that could be obtained by the FBI, and that we cannot tell you that. The Patriot Act does not allow us to inform you that, in effect, what you read or have researched on the computers has been obtained by the FBI. There is a provision, an amendment to the Patriot Act that I hope all of you will support and tell Congress people to support, that is called the SAFE Act. And it's going to be introduced again in another couple of weeks. And it will amend that. It will amend that provision to require that they be talking about, that they be investigating somebody that there is some cause to believe creates suspicion. And by the way, the SAFE Act is supported by and sponsored by Senator Larry Craig of Idaho and supported by the rest of the Idaho delegation. So this is a relatively rare instance where the ACLU is very much trumpeting and supporting the Republican delegation that's in Congress. Section 213 allows sneak and peek. I think Jeff said it's been amended to allow it to be used against terrorists. Well, it's always been able to be used against terrorists. It's just that what they did in the Patriot Act was by statute in the Patriot Act, they provided that you could have sneak and peek provisions. Well, in the past, there have been sneak and peek searches that have been done that are appropriate, that we do not object to, but they are pursuant to court order, where the law enforcement people go to the court and they request, this is a special circumstance. We need to conduct this search surreptitiously and not notify. Fine. If the judge sees unless Congress acts. And Congress is going to start debate in a couple of weeks about the sunset provisions of the Patriot Act. And it's very important that people demand that those provisions do sunset. Those provisions were added to the Patriot Act because they were seen as extraordinarily overreactive, overprotective of security, and over-violative of civil liberties. And we don't need those. What we need is a smarter, better crafted piece of legislation. And it's just a little tweaking of the Patriot Act that Congressman Craig and Senator Craig and these others are pushing. It's a bipartisan bill. It's supported by Senator Kennedy of Massachusetts, as well as Democrat Dick Durbin of Illinois. So it's about 4 or 5 provisions that it would tweak. That is in addition to the fact that we've got to allow the sunsetting to take place of the Patriot Act, of those provisions. There's always the comment about Senator Feinstein. I hear that wherever I go. And the fact is that when the ACLU was responding, they were responding honestly. That we don't know of any. I think they went on, and I know they went on, I'm told they went on to say, well, yeah, because some of this stuff is done so surreptitiously. Nobody knows whose rights are violated. Nobody here knows. I don't know whether or not, the FBI is... They probably do have a record on me because of my background and my work, but what level of surveillance is being done? We don't know. We do know that, we filed a lawsuit against Section 215, and the Muslim communities in Portland have been affected in that they don't have the sense of freedom of association that they would otherwise. Poll, many Americans believe Muslim marriage should have less rights than others. Yeah, I just noted that. That may well be, and that is why we have a U.S. Constitution. Thank goodness we have the ability to protect individual freedoms as against the tyranny of the majority. Because come 9/11, anything would have passed. The Patriot Act got rewritten and printed at 3 a.m. in the morning, and by 11 a.m. that 345-page document had been voted upon. And I don't believe a single congressman or senator read it or understood it if they did try to read it. But the fact is that we have got to be a little bit more careful, and we have got to allow for the individual civil liberties to trump the majority will when it comes to those core freedoms that are protected by the Bill of Rights. Thanks.
Just 2 quick things. I think it's great that in supporting the Patriot Act, I'm citing people like Janet Reno and Dianne Feinstein and Joe Biden, good Democrats all, and that in supporting changing the law, Jack is citing people like Senator Craig, and you could have mentioned Bob Barr, the former arch-conservative Republican from Georgia, I think. If anything, that ought to make it clear that this is not a partisan issue. This is not one that liberals are all on one side and conservatives on the other side, or Democrats and Republicans. This is an American issue. It's a controversial issue on which reasonable people can come to different positions. And I'm not flatly opposed to tweaking the law. I think there are elements of the proposed SAFE Act that make sense, and I hope that they get enacted. My concern today is primarily to try to throw some cold water on this raging notion that all of us are losing our privacy, our civil liberties, and our freedom of speech because of the Patriot Act and other acts that the government has taken in the wake of 9/11. The other thing, I know that the ACLU and the American Library Association have gotten great mileage out of this notion that library records are endangered, and that they've put up these notices in libraries designed to whip people into a frenzy of fear and concern. Folks, it's a huge concocted piece of propaganda. It isn't true. As of the last report that the Justice Department made to Congress on its use of that section of the law, Section 215, which it's required to do every 6 months, it still had never requested a single record from any library. It just ain't happening. And one piece of evidence that this is all a deliberate and cynical attempt to simply gain traction in public relations is an editorial that appeared in Library Journal, the main publication of the American Library Association. It ran in December of 2003. I know you can't see it from here. The headline says, "If we didn't have Attorney General Ashcroft, we would have to invent him." And it went on to talk about what a great boon this has been for raising awareness for libraries' issues. So don't let yourselves be fooled. Section 215, which enables the government with court approval, Jack keeps treading lightly over that part of it. They've got to get court approval before they can go and conduct these searches. It wasn't written to target libraries. Libraries are not in the crosshair. If you go into a library and take anything out or use the computers there, the Attorney General of the United States is not going to come snooping over your shoulder to find out what's at stake. That's been used cynically to try to distract attention from what the purpose of that law really is. And once again, I emphasize the purpose is to prevent another 9/11 from happening, because if that does, we will really see a bad destruction of civil liberty in this country.
Our next question, please.
Hi, Julie Tiger-Liegert. I teach history here at the college. And my question addresses Mr. Jacoby's remarks about the sneak and peek. You mentioned that a criminal defendant receives the full due process of the law as regards to getting an attorney, search warrants, the whole bit, but that somebody who hadn't committed a law yet was not eligible for that due process under the Patriot Act 213. My question is, does that not trample, in your opinion, on the whole presumption of innocence until proven guilty? And if you could clarify that.
Sure. Innocent until proven guilty, legal innocence until proven guilty, is the attitude that the government is supposed to have, that courts are supposed to have, judges and juries are supposed to have, when they're presented with somebody who is being accused by the government of a crime, and if found guilty, will be punished. The law expects that you will regard this person as innocent until the government proves that person's guilt. But that doesn't mean that the government shouldn't be able to take reasonable steps to prevent a crime from occurring in the first place. And if the government were prevented from trying to prevent a crime unless it had first notified the person that it was surveying or that it was focusing on, made sure that he had legal representation, advised him not to do anything without, that the government wouldn't do anything unless he first agreed and consulted with his attorney. Imagine all the death and mayhem that would take place. Not to mention the fact that many of these terrorists aren't even American citizens, and so may not even qualify for those kinds of due process concerns if they are put on trial. The Bill of Rights and comparable measures in state constitutions talk about what protections have to be afforded to a defendant who's on trial. It doesn't say that if somebody is about to commit murder, that the government first has to warn him and then has to provide him with a lawyer and has to make sure that a jury of his peers is judging everything that takes place before he can be stopped. If the policeman sees the guy about to shoot the defenseless victim, the policeman can shoot the murderer, the intended murderer. And I don't think that anybody is going to object that somehow his civil liberties have been violated. On the other hand, if somebody is accused of committing murder and the government arrests him and then throws him into a cell and doesn't give him access to an attorney and insists on trying him in secret and all the rest, then you would say, yes, there's a genuine violation of civil liberties. The great concern post 9/11 has been to prevent further terrorist attacks from taking place. And again, it's just worth emphasizing, those attacks took place by foreign enemies who had secreted themselves on American soil. These were not American citizens who had decided openly that they were going to challenge the government. These were foreigners determined to attack Americans and the American nation and came here to do so. It's part of the basic obligation of the government to provide for the common defense, and one of the important ways of doing so is to prevent these kind of attacks from occurring before they take place.
Yeah, I don't know that I disagree with Jeff on any of those comments. I wanted to point out that that due process is an important right, and it's a right that the innocent are afforded to. Unfortunately, it's not a right that our government is providing. It's not a Patriot Act issue, but it is a post 9/11 issue. And Jeff has written for the Globe, for the Boston Globe, about the torture that is going on in other countries, and that the United States isn't doing enough to prevent. And in fact, we're sending, called rendition, we send people who are suspected out of the country now to countries where they can be tortured. And unfortunately, the people who are responsible for the upper echelon people are not being punished. It appears that they're being promoted. Most recently is Paul Wolfowitz, the new head of the World Bank, who that continues a pattern of rewarding those involved in crafting torture policies with prestigious appointments. I'm looking now at a news release that the ACLU did, and that quotes a friend of mine who notes that as privates and sergeants are getting jail time, top-level officials are getting promotions. Government documents show that the torture of Abu Ghraib wasn't an isolated incident. The only way to get to the bottom of the issue is if we go straight to the top. And we go on to note that Alberto Gonzales, who drafted the memorandums on torture and gave legal advice on the matter as White House counsel, is now our U.S. Attorney General. Michael Chertoff, the force behind the detention of hundreds of Arab, Asian, South Asian, and Muslim men after 9/11, became the Secretary of Homeland Security. And Jay Bybee, the head of the Justice Department Office of Legal Counsel, who signed the notorious August 2002 torture memorandum, was given a lifetime post on our Ninth Circuit Court of Appeals. So there is due process being violated in that way as well.
We'll make this really short. You get 1 minute to answer. I'm going to let Buell ask a question. I've got to go to class, and then we'll have to bring it to hall. But Buell, you're the last one. You get the special last question.
I'm interested in another subject. It seems ironic that the government that is pursuing intrusion into people's private lives is the most secretive in the history of this country. The Bush administration has classified more information than any previous information. It's more difficult for people to get access information through the Freedom of Information Act. I just want to get a response from both of you on what has happened with the public's ability to get access to what the government is doing.
I actually completely agree with you. This is something that was bothering me long before 9/11. The first inkling that I had of it was when this Bush administration prevented the release of papers by the first Bush administration, which were supposed to, after a certain period of years, those were supposed to be made public. And instead, the second Bush administration acted to prevent those papers from being released. They sent out a memo, I think it came from the Attorney General, the Justice Department, essentially instructing all federal agencies to presume that Freedom of Information requests should be turned down, and only if there were countervailing reasons to approve it should they go ahead and approve it. So I completely agree with you. I don't like this secrecy which predates 9/11. It is suggestive to me of a real problem, a lack of trust on the part of many in this administration, and I hope that I won't be the only person who tends to be right of center and who on many issues supports this administration to speak up against it and to oppose it.
Well, great. And I hope I hope I can read a column in the paper by Jeff to explain that, because I think it's important that conservative columnists speak out forcefully about the fact that the government is denying access to the public for information about how it operates. I made this point. I don't need to make it again, but I do see it as tied in with the whole administration effort to have a single mindset in the White House, which is so very dangerous. And that doesn't allow questioning of the president about policies that the president is pushing. It doesn't allow, as we're talking about here, the public to access information about it. We are setting ourselves up for a very dangerous situation when there is no accountability, because the public cannot get access to what the government is doing. And it makes me terribly angry and terribly scared, and I hope that the people react by demanding that the government be opened up. And the place to start, I think, is with our Republican delegation, but also in any other way to advance in letters to the editor and the like, your outrage that we aren't getting access to this public information.
I just want to say on behalf of our committee, you both were just so great to be here, and how very fortunate we are that you came, and what a great, great dialogue. As we adjourn in a moment, they will come down and maybe they can talk to you a little longer. I must go teach a class or get fired. Not really, but I got to go teach a class. And I want to invite you at 1 o'clock. We have a great panel, and we'll be continuing discussion at the Student Union at 1 o'clock. You've been a wonderful audience, and we'll see you later, and thanks very much.
So you're catching flights in?